So I think, folks, we will get started this afternoon. Welcome to our first ever virtual Patrick A. Keenan Memorial Appellate Advocacy Competition. We're thrilled that you can join us, and we're thrilled that we're able to offer this competition this year. So it really has taken a village to bring this competition together. And before we get started, I just wanted to thank a few folks that were instrumental in making this possible. So first of all, I'm one of 4 faculty advisors to the Moot Court Board of Advocates, and the tireless troopers who have been working on putting together this competition also are my colleagues, Professor Jelani Jefferson-Exum, Professor Karen Henning, and Professor Elizabeth Sharofsky. And also, I've been assisted in all of the logistics and legwork, and has just done a phenomenal job and has been a terrific trooper all the way through as well, is the one of our executive members of our Moot Court Board, Mariah Natsky. And the magician who is pulling all of the strings here and making all of this possible is Alex Myers. And so we thank him for his technical expertise. And also just wanted to thank Sunny Kirschenheiter and Grace Henning, our events and media folks, for helping to put all of what you are seeing together. And also, I just wanted to congratulate all of the students that competed in our Keenan competition this year. It was really a lot of fun, and it was really kind of neat doing it online, and now you've got something interesting to add to your CVs. And I just wanted to thank all of you for your patience and your resiliency in competing in this online format. And finally, just thank Dean Crocker for her continued support of our Moot Court program. And with that, I'll turn it over to Dean Crocker, who's going to recognize some very special guests that we have with us today.
Thank you, Professor St. John. I want to begin by acknowledging what incredible work Professor St. John has done with pulling all of this together. So thank you very much. I have the privilege of recognizing the Keenan family today. This competition is named for Professor Patrick Keenan, who taught here for 30 years. He was a beloved professor, not only by students, but also by faculty and staff and administrators who got to work with him every day. His family is here today. I know that his wife Marge is here and others are here, some who usually don't get to attend. Many of them attend every year, but because we're doing it on Zoom, more of them get to attend, which I just think is lovely. So welcome to all of you. It's a real pleasure for us to have you here. Now I'll turn it back to you, Professor St. John.
Thank you. Yes, and we are thrilled that the Keenan family members are able to attend. I just wanted, before we head into the competition, just say a couple of words about Professor Keenan, in that I was struck by the responses when we send out the emails soliciting judges to volunteer their time to judge our Moot Court. And I was struck by the number of alumni that responded that they would be absolutely pleased to participate in this competition that bears Professor Keenan's name and is done in his honor. And one of the, I just wanted to take an example of one of the emails that I had received, and it was from an alumni who, in the course of her work, reviews search warrants prior to submitting them before the magistrate. And she said that just today I denied a search warrant based on First Amendment grounds. I can feel Professor Keenan smiling, and I'm honored to participate to continue to bear his legacy. So that was just sort of an example of some of the sentiments that were expressed about Professor Keenan. So without further ado, we will turn to the competition that is made in his honor and that bears his name. And today, our oralists are, for the petitioner, Beau Exotic, we have Nadine Dabaja and Deja Davis. Respondents on behalf of the United States of America, we have Sabrina Mangiapane and Amanat Sandhu. This afternoon, our esteemed judges Joining us today are Judge White of the Sixth Circuit Court of Appeals. We have Justice Zara of the Michigan Supreme Court, and we have Judge Langford Morris of the Oakland County Circuit Court. So thank you very much for joining us this afternoon, and I will turn the proceedings over to our esteemed panel of judges.
Thank you very much. It's always an honor and a privilege to participate in the Keenan Moot Court competition. I'd like to extend my welcome and hellos to the Keenan family. Mrs. Keenan, I can't see you right now, but I will before this is all over. And Vince and all others who are here. It's always a pleasure to be part of this event. We'll talk more about Professor Keenan afterwards, but let's get this argument started. Do we have a bailiff who's going to call the case?
I'll be calling the case today, Your Honor.
Okay, let's call the case.
Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. You may begin.
Good afternoon, Your Honors, and may it please the court. Nadine DeBaja on behalf of petitioner. At this time, we'd like to reserve 1 minute for rebuttal, please.
Okay, do we have someone tracking your time?
Yes, we do, Your Honor.
Okay, please proceed.
Your Honors, this is a case about protecting the individual rights and freedoms granted to citizens of this country and upholding the promise made to them by the Constitution and centuries of practice. Accordingly, we respectfully ask this court to reverse the 13th Circuit Court's holding that Beau Exotic was not seized within meaning of the Fourth Amendment, and further, that evidence of Ron Kinley's mental state should be excluded. I will be discussing the seizure, and my co-counsel, Deja Davis, will be discussing the application of 18 U.S.C. Section 111 to the present case. Your Honors, an officer demanding that a person leave an area in which he is legally protesting and later blocking his course with her hands placed at her hips constitutes a seizure within the meaning of the Fourth Amendment. This court should find that Agent Lafferty effectively seized Beau Exotic within meaning of the Fourth Amendment for the following two reasons. First, Agent Lafferty demonstrated a show of authority as an FBI special agent, and second, Beau Exotic submitted to that show of authority. This court has long recognized that the Fourth Amendment's protection against unreasonable seizures includes seizure of the person. To constitute a seizure of the person, within meaning of the Fourth Amendment, there must either be the use of physical force, or where that is absent, submission to a show of authority.
In what way did he submit to the show of authority?
I'm sorry, Your Honor, can you repeat the question?
In what way did he submit to the show of authority?
That brings me to my second point, Your Honor. Under the totality of the circumstances in the present case, Beau Exotic did respond to Agent Lafferty's show of authority by passive acquiescence. This court recognized in Brundtland that an inquiry into whether an individual effectively submitted to an officer's show of authority depends on the particular facts at hand, and further, that what may amount to submission depends on what the defendant was doing before the officer's show of authority. Brundtland ultimately provides that an individual who passively acquiesces to an officer's show of authority is said to have submitted to that show of authority enough to constitute a seizure. To determine whether an individual's passive acquiescence amounts to submission, courts consider whether a reasonable person would feel free to decline the officer's request or otherwise terminate the encounter. Judge Langford Morris, I see that you have a question, but you're on mute.
Wouldn't Exotic have to have fully complied with the officer's request? Instead, he went for his megaphone.
No, Your Honor, it is within this court's precedent that, and lower court's precedent also, that an individual does not necessarily have to comply with the officer's specific request in order to be seized within meaning of the Fourth Amendment. In Brundtland, the defendant inside of a vehicle was pulled over by the officers, and this court found that an individual who remains in place following a show of authority has effectively submitted to that show of authority enough to constitute a seizure by way of passive acquiescence. When Exotic remained in place after Agent Lafferty stepped in front of him as he walked towards the sanctuary, he submitted to her authority by passively acquiescing to it. A reasonable person in his position would have believed that he was not free to disregard her request and continue freely going about his business. As to my first point, Your Honors, Under the totality of the circumstances, Agent Lafferty's conduct amounted to her show of authority as an FBI special agent. In US v. Mendenhall, this court provided a non-exhaustive list of examples of circumstances under which, when considered in their totality, indicate a Fourth Amendment seizure, some of which include the threatening presence of several police officers, some physical touching of the person of the citizen, and use of language or tone of voice indicating that compliance with the officer's request is compelled, all of which were present here, Your Honors, among other things. Enough Hosmer City Police.
Counsel, she didn't tell him to stop. She told him to move along, right?
That is correct, Your Honor.
Okay. So at that point, he was free to go anywhere, right?
Your Honor, it is our position today that the 13th Circuit erred in its analysis of this case on appeal when it limited the question on appeal to whether a reasonable person would feel free to leave. This court instructed that in an instance where an individual has no desire to leave, the more appropriate inquiry is to whether that individual or a reasonable person under the circumstances would have felt free to decline the officer's request or otherwise terminate the encounter. And it is our position today that Beau Exotic and a reasonable person under these very circumstances would have felt that he was not at liberty to decline the officer's request or otherwise terminate the encounter. Agent Lafferty.
I'm sorry, let me ask, is that the case you're relying on, is that the Bostic case?
Yes, Your Honor, it is.
That really didn't apply the Mendenhall factors, did it?
Your Honor, in Florida v. Bostic, the court did inquire into whether a reasonable person would have declined the officer's request or otherwise terminate the encounter. And I'm not exactly sure whether they use the Mendenhall factors or not, but it is our position today.
I understand, but the Bostic test is different from the Mendenhall test. Don't you agree?
Your Honor, I respectfully disagree. I believe that there are two tests that this court has used and lower courts have used to determine whether an individual has been seized. One being the free to leave test, and the second being the Bostic test that asks whether a reasonable person would have felt free to decline the officer's request or otherwise terminate the encounter.
I think that's my point. I think that's my point. These are two different tests. They're different. Which one is better suited to be adopted by this court? Mendenhall was a plurality opinion. Should we take this opportunity to embrace Mendenhall and say that is the test? Or do we look at the Bostic case and we take the lead from Bostic and say, you know what, Mendenhall was a plurality. It sets forth some factors, but the real question should be whether the reasonable person would feel at liberty to ignore the police presence and go about their business.
Your Honor, it is our position today that this court should follow the Bostic test and conduct its analysis of the present case under the Bostic test.
Isn't that too subjective of a test? I mean, it might work well here, but how do we apply it to the next 100 cases that come through?
In the same way, Your Honor, this is a totality of the circumstances analysis, and the Bostic test allows for exactly that. It's when the court in Bostic instructed that the test be whether a reasonable person under the circumstances would have felt free to decline the officer's request or otherwise terminate the encounter. The court there was effectively employing an objective test that applies across the board. Any case that comes before this court and applying the Bostic.
Isn't it true that in this case, Bostic really is a little complicated because we have a lone FBI female agent that simply gently took him by the arm. And how do we don't have several police officers in the area. They weren't right there with her. It was a single female police officer. So how do you distinguish that under the multi-factor test as set forth in Mendenhall?
Your Honor, enough Hosmer City police officers were present at the scene to barricade the entire sanctuary, along with FBI Special Agents Lafferty and Jameson when she later radioed him to assist her. It is true that this court has held that officers may employ a certain guiding force in ensuring obedience by the subject. However, it is our position that her touching of his arm, along with the totality of the rest of the circumstances, is what eventually led to a seizure when Beau Exotic submitted to that show of authority. Agent Lafferty made her command in a contentious tone of voice. She told Exotic, "Look, I'm not playing nice anymore. You need to get the hell out of here right now. I'm not going to warn you again." It was at this moment that Agent Lafferty also decided to radio her partner, Agent Jameson, to assist her. Agent Lafferty spoke to him in this way, all while standing in front of him, blocking his course with her hands placed at her hips. When Agent Lafferty says, "I'm not going to warn you again. I'm not playing nice anymore," there are many police officers standing right behind her, blocking the sanctuary. Agent Jameson has now approached her, not only one FBI special agent, but two, alongside their marked police vehicles in uniform, would lead a reasonable person under the same circumstances to believe that if I terminate this encounter with Agent Lafferty, there will be consequences, and that I am not at liberty to terminate this encounter or decline her request.
You know what? I understand why you like totality of the circumstances tests, because they can be argued and fit into almost any circumstance, and it comes down to a matter of advocacy. But quite frankly, I prefer tests that provide certainty in the law. Why shouldn't we hold that move-on orders by themselves without more as a matter of law are not seizures under the Fourth Amendment?
Your Honor, this court has previously held that move-on orders on their own, on their face, are not unconstitutional. And it is our position today that tests like the Bostic test that allow for totality of the circumstances analysis is exactly where the court is making room for not only police officers to engage in their federal functions and issue move-on orders to promote the public safety, but also protecting the individual rights and obligations that we have to citizens of this country.
I appreciate what you're saying, but I'm trying to get away from totality tests because I don't believe they provide enough certainty. Now, maybe I end up in the dissent. I guess the question is, what rules can we make? So if we say move-on orders alone are not enough for a seizure, what about move-on orders with physical contact? Would that be a better test?
No, Your Honor. It is our position today that an individual can be seized within meaning of the Fourth Amendment, even when he is not physically touched by the officer. In fact, lower courts have decided in this way exactly. For instance, in US v. Black,
I get to decide here. I'm on the Supreme Court of the United States now, right? We don't have to follow those lower courts. I prefer a test that has physical contact. Now, the question I have is, if we add physical contact, how do we discern, how do we articulate for lower courts how much physical contact is necessary? If we were to adopt a physical contact test, what would you say the test should be? Any physical contact, excessive physical contact? How would you draw that line?
Your Honor, it is our position today that drawing a bright line rule that constitutes whether a move-on order is a seizure or not in the presence of physical contact would be stripping this court of its ability to actually analyze the circumstances that happened in each case specifically. Every encounter with a police officer is going to go differently. Police officers are going to issue their move-on orders differently depending on the situation, depending on the defendant that they're dealing with. And it is our position today that adopting a bright line rule that says that move-on orders with or without physical force, or whatever the factor that you may choose, Justice Zara, would rob individual defendants of their right to be considered under the totality of their circumstances.
Well,
and also,
I want to weigh in on this. I agree with my esteemed colleague that we need to delve further into this, because as far back as Terry versus Ohio, the seizure issue, it was only dealt with if there was a physical force and a show of authority. And in some way, a citizen was restrained. So you're asking us to leap forward and create basically new law that would allow for no restraining of the individual, just simply a move-on order and someone putting their hands on their hips.
Your Honor, we respectfully disagree that this was not simply a move-on order. This was more than a move-on order. And like I mentioned before, it is true that move-on orders are not on their face unconstitutional. However, it is our position today that the facts that we have before us under the totality of the circumstances constitute more than a move-on order. Agent Lafferty didn't just stand in front of Exotic and tell him to move away from the side of the road. She used a contentious tone of voice. She displayed her badge, radioed another FBI special agent to join her on the scene, several Hosmer City police officers were also there at the scene, would lead a reasonable person to believe that he was not at liberty to decline her request or otherwise terminate the encounter. And it is in this instance.
Isn't that the nature of a move on order? That the officer is telling you, you can't be right here anymore. You can go wherever else you want, but you can't be right here anymore. And presumably the person feels compelled to follow it, but how is that a seizure?
Your Honor, I'd like to point you to the Second Circuit's rationale in Salmon v. Blesser, where they held that a move on order without more is not a seizure, as this bench points out today. They characterized a move on order as where an officer orders a person to move, the person feels obliged to obey, they employ some certain level of guiding force, and that is still a move on order and not necessarily a seizure. However, they did distinguish that when an officer intentionally restrains and controls the movement of a person, it is effectively a seizure. And in this case, Your Honors, Agent Lafferty effectively blocked Exotic's course in where he was standing and protesting, and effectively seized him right then and there when he passively acquiesced to it. He stopped in his place, did exactly as she commanded, got the hell out of where he was, and did not stay on the side of the road. It was Agent Lafferty's intention to promote the public safety and get Exotic out of the side of the road. Your Honor, I see
But
my
you're
time
not analogizing these facts to the Salmon versus Blesser Second Circuit decision, where we had an individual that was complaining, got ejected from a courthouse, and it was grabbed, the collar was twisted, his arm behind him. Our agent didn't do anything close to that.
Your Honor, I see my time is up. May I answer your question and briefly conclude?
Yes.
No, Your Honor, we are not comparing the facts of Salmon v. Blesser to the facts of the present case. However, I was just pointing the bench to the rationale that the court employed in that case to distinguish between a move on order and a seizure. Your Honors, under the totality of the circumstances where we have an agent, an FBI special agent, not one, but two FBI special agents in the presence of many Hosmer City police officers, after an FBI special agent badge has been flashed, she has effectively blocked his course with her hands placed at her hips, telling him, "I'm not going to warn you again." A reasonable person under those circumstances would not have felt free to decline the request or otherwise terminate the encounter in fear of its consequences. Accordingly, we respectfully ask this court to reverse the 13th Circuit Court's holding that Beau Exotic was not seized within meaning of the Fourth Amendment. Thank you.
Thank you.
Thank you.
Thank you.
You still have some time reserved for rebuttal, correct?
Yes, we do.
Okay, great. Who's next? Ms. Davis? Or are we going to hear from the other side before we go?
Yes, I will go next. We're going to turn our cameras off so I can place my laptop before
Okay.
getting started.
Okay.
May I begin when ready, Your Honors?
Yes, please.
Good afternoon, Your Honors, and may it please the court. My name is Deja Davis, and I represent the petitioner. I will be addressing the application of 18 U.S.C. Section 111. Your Honors, Section 111 authorizes enhanced punishments for specific criminal acts committed against federal officers. And where an enhanced punishment may result from an individual's conduct, the interpretation of the statute is critical as to the impact it has on individual freedoms. Accordingly, the 13th Circuit erroneously precluded evidence of Ron Kenley's mental state, and we respectfully ask this court to reverse the 13th Circuit's holding for the following two reasons. First, the 13th Circuit failed to consider the common law definition of assault in its statutory interpretation analysis. And second, Section 111 requires specific intent to protect individuals from being held liable for trivial or innocent conduct. As to my first point, Your Honors, Section 111 makes it a crime to forcibly assault, resist, oppose, impede, intimidate, or interfere with a federal officer while engaged in or on account of performance of official duties. The circuits are split as to whether this statute requires specific intent, and courts have taken different approaches to discern the proper scienter. General intent requires an intent to do a criminal act. Specific intent requires an additional showing that the actor intended a certain criminal consequence. The statute here is silent as to the requisite intent, and generally courts will look to the plain language of the statute to determine its intended purpose. However, intent can be determined here from the common law definition of assault and this very court's articulated standard for addressing silent mental elements in Morissette.
Counsel, I appreciate your argument. I even know there's case law to support this notion of going to the common law. But I must tell you, I was a bit puzzled when, as a question of interpretation of a federal statute, there's an argument that we should look to state common law as to what assault means. Federal law is quite distinct from state common law, and common law can change from state to state. So do we have a different interpretation of this federal statute in each state if we look to the common law? It seems to me the common law is dictated by the policies and mores of the individual state and really has no play in how we interpret this federal statute. Why am I wrong on that?
Your Honor, this very court stated in Morissette that where Congress is silent as to the mental elements in an act and merely adopts a concept of crime into federal law that is so well defined in common law and statutory interpretation, it may warrant quite contrary inferences than the same silence in a new offense who has no guidance besides the act. And the court actually went further to say that where Congress borrows terms of art that have accumulated the legal tradition and meaning of centuries of practice, it presumably knows and adopts the cluster of ideas that are attached to each borrowed word unless otherwise instructed.
So if the common law is different from California than it is in Michigan, do we interpret the same federal statute differently?
Generally, Your Honor, when it comes to this statute in specific, assault has always required a finding of specific intent. And today we're here to say that since it requires specific intent and common law has always found it to require specific intent to commit that act, then the court should adopt the cluster of ideas that surround that word.
All right, well, let me take you a different approach since you aren't biting on that one for me. You say it's a matter of statutory interpretation. Are there not some clues in the text of the statute before I ever get to this notion of common law? Are there not some clues in the statute that might help us to discern whether Congress intended this to be a specific intent crime?
No, Your Honor. Here, although the statute does have the word forcibly, and that may seem to add another layer of intent to make this not as plain as one might lead you to believe, forcibly just means to affect by force, which anyone can do trivially or innocently. You can push someone and affect them by force. So that doesn't change the
What about
inquiry here.
resist? What about the word resists or interferes? Doesn't it have to have some mens rea, some intent to do that? Don't you have to intend to resist?
Yes, Your Honor. And the specified crimes of resisting, opposing, impeding, intimidating, or interfering with a federal officer are common obstruction crimes. And this very court held in Pettibone that obstruction of justice crimes require specific intent. So when Congress drafted the statute and put the specified crimes together, borrowed terms of art that have accumulated the legal tradition and meaning to require specific intent, and naturally opposes the interpretation that the statute requires specific intent itself.
Okay.
Returning to my first point, Your Honor.
So how would you, I'm sorry, you said something earlier about requiring that you intended the act, but how would you define specific intent here? What would be required?
So, Your Honor, general intent requires that you intend to do the criminal act. Specific intent requires an additional showing that you intended a certain criminal consequence. So not just the act itself, but the consequence that the act would bring once committed.
How would that operate here with this statute?
So, Your Honor, in this statute, Ron Kinley would have had to possess the intent to commit a certain criminal consequence after he did the intended act. So go past general intent. And assault itself has always required more than a mere wrongdoing or a mere intent to act, which goes beyond the general intent. They needed to want to inflict bodily harm upon someone to be held liable for intent or assault under common law.
Okay, so you're saying in this case, it is the intent to commit bodily harm?
Yes, the intent to have the consequence be assault. Yes, Your Honor. Returning to my first point, Your Honors, this very court in Morissette held that the omission of intent from the statute does not effectuate its elimination from the element of the crimes denounced. In that case, this court stated that stripping the statute of guilty intent requirement eases the prosecution's path towards conviction and strips the defendant of the benefit he derived at common law. And Your Honors, the same principle applies here. Section 111 is silent as to whether it requires.
Counsel, wouldn't this, if we were to rule the way you're arguing, wouldn't this open the floodgates for attacks on federal agents, police officers, employees that are trying to do their duties? You're asking us to make a finding that would require a higher burden than what the statute notes. The statute is specific on its face. It says clearly, assaults, resist, opposes, impedes, intimidates, or interfered.
Yes, Your Honor, and that's what we're asking today, to find that it's specific and requires specific intent, because the crimes denounced have required specific intent under common law. And this very court has held that adoption of those crimes and their well-defined meanings and their cluster of ideas that are attached will be presumably adopted when Congress does not give other instruction. It does not necessarily open the floodgates to attacks on federal officers. The statute still protects federal officers and federal functions. Under the statute and under this court's precedent in FIOLA, the only thing that is general intent is the intended circumstances of the victim's identity. Officers are still protected because they may bring this charge under Section 111, whether the person intended to hurt them or whether the person knew that they were an officer or not. So,
okay, so what is it here that would make Kinley not know what it was that he was doing? What facts are you relying upon?
Your Honors, Ron Kinley at the time of the encounter was intoxicated and had taken a drug at the time. He did not possess the requisite intent to actually harm Agent Lafferty at the time of the incident.
But didn't he have a 0.12 blood alcohol level and methamphetamine? So those things didn't jump inside of his body. He picked up a glass or a bottle of something and drank it, and he ingested something for the methamphetamine. These are not things that attacked him. These were overt actions by Mr. Kinley, weren't they?
Yes, Your Honor. But in making this finding, we must also recognize that the same act can be done by someone trivially or innocently or with a diminished capacity. And we must protect those people who commit these acts and do not mean to do them and do not intend to hurt an officer. And if we allow general intent, any evidence or any circumstances that surround their case would not be presented to a jury. All they need is the intent to do the act. So if they intended to push a federal officer, then that's all that the jury will look at once making this determination if this was a general intent statute.
You know, you mentioned the FIOLA case. Doesn't that strongly weigh in favor? I mean, I understand it was a 1983 case, and it's, you know, we'd have to draw some analogies, but it certainly seems to me that that case strongly weighs in favor of this being found to be a general intent crime. Why am I wrong on that?
Your Honor, it does not weigh in favor of a general intent crime. The holding in FIOLA was extremely narrow. The holding said that it requires general intent because the defendant need not be consciously aware of the victim's identity. They only decided on one element of the act itself. The Seventh Circuit in Staggs interpreted Section 111 following the holding of Viola, and the court stated that the statutory language of Section 111 gives no clue as to whether specific intent is required. However, the specific intent to commit assault is a prerequisite under the statute, and the court used the reasoning in Viola that stated, all the statute requires is an intent to assault, not an intent to assault a federal officer. And we are not to be understood as implying that the defendant's state of knowledge is never a relevant consideration under Section 111. And Your Honors, the defendant's state of mind is relevant here as to the substantive crimes. The Seventh Circuit reasoned that mens rea necessary to commit the crime of assault can be negated under this statute. Thus, the court concluded that subjective intent to assault is required for prosecution, and introducing evidence of the mental state of the defendant is proper. The 13th Circuit's streamlined focus on that notion that Congress enacted Section 111 to protect both federal officers and federal functions and furtherance of one policy advances the other is misplaced because they only decided on the one element of the attended victim's identity. The defendant in Staggs, similar to Kenley, was aware of the officer's official status, and the court did not find the defendant's knowledge of the officer to be at issue. Instead, the court reasoned that specific intent is required to commit assault under Section 111 because mens rea cannot be negated for the crime of assault. Whether the defendant has knowledge of the officer's official status, this court must find that the objective to complete assault was still present. The need to protect federal officers and federal functions is not outdone by requiring specific intent to commit the crimes under Section 111. In fact, Your Honors, it
does require, the general intent does require an intent to do the act. So you have to intend to resist, you have to intend to assault, you have to intend to do these things. Do you think Congress intended to excuse people who voluntarily put themselves in the position where, although they intend to do the act, they can't form the intent to harm? I mean, how does that protect federal officers?
Your Honor, the crimes of assault, resisting, oppose, impeding, intimidating, or interfering with a federal officer all require specific intent. For the obstruction of justice crimes, they must have knowledge that justice was being administered to be in violation of that crime.
How does that serve the congressional intent to protect federal officers?
Your Honor, if it's within this court's interest to protect people, and we must remember that although Congress enacted this to protect federal officers and their functions, it's their duty to protect individuals and our citizens as well. And it brings the focus back to individuals because police officers are still protected because the defendant need not be aware that the victim is a federal officer to be held liable under the statute. They are still protected in that way, but requiring specific intent also gives our citizens protection from being held criminally liable for trivial or innocent conduct.
Now hang on that point. Doesn't the word forcibly at the beginning of this statute just undercut that argument? How can any innocent conduct be charged under this statute when the assailant must forcibly assault? There's nothing accidental about forcibly, is there?
Yes, Your Honor. To restate my previous point, forcibly just means to effect by force. I see my time is up. May I briefly conclude or answer your question and briefly conclude, Your Honor?
Please do.
Forcibly requires to effect by force. If you have a mother with her child and her child is falling and there's a federal officer standing next to her and she pushes the officer to protect her child, that's potentially trivial or innocent conduct because she's protecting her child in that moment, but she did effect force and she did intend to push the federal officer. If that ended, she could be held criminally liable under Section 111. And if the jury got that information, they would only get the information regarding her force, the effected force, and the intent to push, but not the fact that she was doing it to protect her child. So a general intent finding allows for trivial or innocent conduct to be held unliable under the statute. And Your Honors, because common law assault requires specific intent, this court instructed that the well-defined common law understanding of crimes are presumably adopted, and a finding in that favor supports the preservation of individual freedoms. We respectfully ask this court to reverse the 13th Circuit's holding and deny the motion to preclude evidence of Ron Kenley's mental state. Thank you, Your Honors.
Thank you. Do we need a moment to convert to opposing counsel?
No.
Okay,
May it please the court. My name is Sabrina Manjapane, and my co-counsel here is Amanat Sandhu. And together we represent the respondent, the United States, in this matter today. Your Honors, there are two issues in dispute arising from May 12, 2018, when Bo Exotic and Ron Kinley attended a rally organized by Exotic to take place in front of Cheryl Haskin's large cat sanctuary. I will be arguing that Bo Exotic was not seized when Agent Lafferty issued her move-on order, and my co-counsel will be addressing 18 U.S.C. Section 111 as being a general intent offense. With respect to the first issue, Your Honors, Bo Exotic was not seized for the purposes of the Fourth Amendment for the following two reasons. First, the interaction between Lafferty and Exotic does not meet the test as to whether a seizure occurred as set out in common law. And second, Agent Lafferty issued a move-on order which generally do not constitute as seizures in violation of the Fourth Amendment. The Fourth Amendment provides that people have the right to be secure against unreasonable searches and seizures. And this court has held in United States versus Mendenhall that a person is seized within the meaning of the Fourth Amendment if, in view of all the circumstances surrounding the incident, a reasonable person would have believed that he was not free to leave. For an action to constitute a seizure, there must have been physical force or a show of authority. And to effect a seizure, a person's freedom of movement must be terminated or restricted. And finally,
counsel, is it fair to say that we held in Mendenhall? Because I understood Mendenhall to be a plurality opinion.
yes, Your Honor.
So did we hold, or is it a plurality opinion? Is it stare decisis, or is it an opinion that can help us with some guidance here, but it's not binding on us?
It is an opinion that can help us here today.
Thank you.
So finally, from that test, the subject must submit. And in applying the Mendenhall test to Exotic's case, we will see that there was no termination of his freedom of movement. As explained by this court in California versus Hadari, the test for a show of authority is an objective one. It is not whether the citizen perceived that he was being ordered. It is not whether the citizen perceived that he was being ordered to restrict his movement, but whether the officer's words and actions would have conveyed that to a reasonable person.
Is there any question at all that he was instructed that he had to move and that if he hadn't moved, he would have been arrested?
No, Your Honor. The facts indicate that he was free to go wherever else he pleased. This was
he couldn't stay there.
that's
Is there
right.
any question that if he had not moved, if he had just stayed where he was, he was going to be seized?
No, Your Honor. This actually brings me to my second point, being that this was a move-on order. There was no indication that he would have been arrested if he didn't leave. However, police officers have the authority to ensure that move-on orders are complied with. So her move-on order does not constitute as a seizure because a move-on order occurs when a person is required not to occupy a certain space. When ordered to occupy another space, a person's continued freedom is not restricted, considering that the order brings about minimal intrusion upon personal liberty. Unless the move-on order involves physical force to the point where an individual's movements are controlled, there is no plausible allegation here that Exotic can make to equate Lafferty's actions with that of a seizure.
Okay, so let's stop there. I personally like a test that would have not more than a move-on order, some move-on order with some physical conduct. How much force would be required before it is a violation of the Fourth Amendment? How would you articulate it, and how would that test apply in future cases?
Well, Your Honor, it's hard to say whether specific conduct would amount to there having been a seizure. I can provide examples as to how courts in the past have viewed an officer's conduct when issuing a move-on order as being a seizure, but it's hard to define an officer's actions because we would risk defining any officer's actions as being a move-on order, such as standing in front of a person. We cannot say that just standing in front of someone is a seizure because police officers frequently will do that.
You might have misunderstood my question, or I misunderstood your answer. I'm not a fan of just simply saying a move-on order is a seizure, but a move-on order plus some physical conduct. How much physical contact then do we draw the line? Is merely putting your hand on someone's elbow and gently putting them in the direction you'd like them to move on to enough to be a seizure? Or is it excessive force that's required, force above and beyond what it takes to enforce the order? Where do we draw the line?
Your Honor, we would draw the line at when there is excessive, force, just to the point where an individual's freedom of movement is controlled. So it would have to go to the point where liberty is actually inflicted upon for the purposes of the Fourth Amendment.
Would you classify this as a totality of the circumstance test, or is it clearer than that?
I would classify this as a totality of the circumstance test, just because it's hard to define, each officer's actions as, exceeding the scope of whether or not there is a seizure, because then anything could amount to a seizure so long as you meet certain bullet points.
And does Bostic apply?
Your Honor, as the petitioner has mentioned, Bostic applies so far as Exotic not wanting to leave the premises. So the petitioner has mentioned that we are to examine the facts as to whether a reasonable person would not feel they were at liberty to ignore the police presence or terminate their encounter with the police. So even with the Bostic test, there is no seizure here because Exotic did feel he could terminate the encounter. He did so on 3 occasions.
But I'd like to follow up on my esteemed colleagues' questions. Today, we have a lot of protesting going on in America. We have police that have to intervene. And so how would you articulate the level of force that would be allowed at this state, given your argument? How would we ensure that an innocent person was not injured as a result of police misconduct? Can you articulate that?
Well, Your Honor, it would have to not go so far as to restrict their personal liberty. So in terms of the protests that were occurring, Exotic was not told he cannot protest. His right to protest was not infringed upon. It was not a claim brought by the petitioner. And further to that, so long as the officers' move on order is not inflicting upon their personal liberty, then officers are charged with ensuring public order, for example, and they are charged with being able to order people to move on from a certain space so as to ensure public safety.
Well, how did it not impinge on his liberty? I mean, he was told, go away and don't protest here.
Well, Your Honor, it doesn't infringe on his liberty because, as mentioned, police officers frequently will order people to leave public areas such as public disorder. And in this particular case, Agent Lafferty had told him, you can go anywhere else you want. It's just too much for right here. And she was correct in that it was too much for right there because Exotic was on the side of the sanctuary. He had about 50 supporters with him, and Haskins supporters were across the road. There were also violent signs being depicted. On the internet, they had a very public feud. So it's not that Agent Lafferty's actions were so arbitrary. It's just that in that moment, in that area, and because there was traffic on the road, it did not go so far as being arbitrary and his right to protest in any way because he was able to do it anywhere else except for that location. So further, Your Honors, as the petitioner has mentioned or has asserted, they say that Exotic did submit to Lafferty's authority because he stopped doing what he was doing. However, it is our position that he did not stop doing what he was doing because he said no on 3 occasions and still made his way towards the sanctuary. So Lafferty standing in front of him and told him that he can keep protesting down the road. It was just too much for where they were.
Do you have any supporting authority for the time line that he stopped? Are you arguing that it was a temporary stop, or what are you saying we should rule as far as the timeline on compliance with an officer's request?
Well, Your Honor, the facts do not indicate how long that he was there and interacting with Agent Lafferty. From reading the facts, it seems as though it was not a very long interaction, but I can give the example of, for example, California versus Hidari, where an individual had tried to evade seizure on many occasions. And despite the fact that the officer was chasing someone for quite some time, it made the person come to a halt. The person did not comply with the order or submit until he was actually tackled. So this is an example where we see that there was attempted seizure, attempted seizure basically before submission. And that was not found to have violated his rights because he did try an attempt to evade the seizure. And we also see this in the case of United States versus Stover, where in this case, a police vehicle had pulled up beside Stover, ordered him to stay in the car, but Stover got out of the car and was walking around. And it wasn't until the officer had held up his gun to make him stop that he submitted. So this is just another example where we see someone attempting to evade seizure until they were ultimately arrested. So further, Your Honors, there are contravailing factors to there having been a seizure here. So she did not keep her hand on him. Page 309 of the fact pattern indicates that she touched his arm to get his attention because, again, there were a lot of people and he was moving towards the sanctuary. She did not display a weapon. He was free to go anywhere else but the premises. He obviously felt free to terminate his encounter because he said no on the first 2 occasions before inciting a riot. And further, the threat that the petitioner brings up, it was vague. She did not say he was going to be arrested. It was a loose threat at best. And according to the case of Kernatz versus O'Sullivan, loose threats do not go so far to characterize a Fourth Amendment seizure. And in that case in particular,
Counsel, if she had touched his arm, had her hand on his elbow, kept it there, and said, "You cannot stay here. You can go wherever else you want, down the road, whatever, but you cannot stay here." And if she had walked him out under her control, is that a seizure?
well, Your Honor, I would agree that that would definitely change the circumstances here, and it would bring a plausible allegation of a Fourth Amendment violation. However, that is not the case here, that she kept her hands on him. She did not grab him. The facts don't indicate that she touched him or grabbed him anyway to control him. It was really just to get his attention. So under those circumstances, Your Honor, that you laid out, there's more likely to have been a Fourth Amendment plausible violation here. However,
Well,
that is not the case here.
I mean, I think we agree that he couldn't stay, right? I mean, it's not reasonable to think that he could have stayed without repercussions. So what is the difference between saying what she said and momentarily touching him and leaving her hand there as she escorts him? What is the difference?
Well, Your Honor, the difference would be that she would actually be controlling his movements, but that is not the case here. She did not control his movements in any way, such as, grabbing him and bringing him, out of the grounds. But again, police officers, they frequently will order people to leave certain places, such as areas of public disorder, such as the one in the case here. And a person, despite feeling obliged to obey such an order, and despite a police officer even taking a person by the elbow or employing a certain guiding force, short of actual restraint to ensure obedience with the departure order, is not a Fourth Amendment allegation. Our precedent does not view police conduct without...
Short of what?
Short of actual restraint. Our precedent does not view such police conduct without anything more as being a seizure under the Fourth Amendment, so long as the person is otherwise free to go where he wishes. And that is certainly the case here. And this comes from the case of Salmon versus Blesser, as the petitioner has brought up, but failed to mention that the facts of Salmon versus Blesser are quite distinguishable from the case of Exotic's case. And the rationale, sorry, Your Honor.
I'm sorry. So I hear you saying that the difference is, you're saying the difference is the physical part, but I've also hear you say that the difference is that you're free to go anywhere else. So which is it? Is it that move-on orders, including those with a hand on the elbow, are okay as long as you can go anywhere else? Or is it that if you touch someone and exercise control of their body, that is a Fourth Amendment violation, even if you're just taking them out and then they can go everywhere else? So which is it?
No, Your Honor, it is not just by touching them or guiding them to go somewhere else. It is, as the case law indicates, it's whether or not a person's liberty has been restrained. And we have to remember that that is what the Fourth Amendment protects. Your Honors, I see my time is up. May I take a brief moment to conclude?
Please do.
So to conclude, Your Honors, Exotic's Fourth Amendment claims here are not plausible and should be dismissed. Exotic's movement was not restricted or controlled. He did not at any point submit to Agent Lafferty's authority, and overall, this was a move on order. If there are no further questions, these are my submissions, and my co-counsel will now address the second issue. Thank you.
Thank you very much.
Thank you.
Good afternoon, Your Honors, and may it please the court. My name is Amanat Sandhu, and I, alongside my co-counsel, am here on behalf of the respondent. I will be addressing Section 111 of Title 18 as a general intent offense for the following 3 reasons. First, the plain language of the statute requires a finding that Section 111 is a general intent offense. Second, the presumption of scienter is met with a holding that Section 111 is a general intent offense. And lastly, finding that the statute is a general intent offense best effectuates the dual purpose Congress had in creating this statute and allows this court to affirm the decisions of the majority of circuit courts. First, Your Honors, the plain language of this statute requires a finding that Section 111 is a general intent offense. Upon a plain language reading of Section 111, it clearly does not require that the government prove specific intent. All that is required is that the defendant had the intention to make the bodily movement that constitutes the crime. Nowhere in the statute.
Counsel, as you might have picked up from my questioning, I'm not fond of using common law, state common law, to give meaning to a federal statute. But there is plenty of case law out there supporting this notion. So can you give me a rational basis or reason why we should reject this case law and not look to the common law in this instance to conclude that because common law assault would be a specific intent crime, this particular assaultive statute under federal law would require a specific intent as well?
Yes, Your Honor. We understand that common law in the assault definition of common law requires specific intent. However, our argument is that in this case and in this statute, we should not be looking at the common law definition of assault as a whole because of the whole statute on its face. It uses the terms forcibly within the language of the statute. And we also need to look at the dual purpose of the statute in order to best effectuate what Congress wanted in making this statute. This court has found in United States versus Carter, where there is an element of force, all we really require is the sufficient mens rea to establish wrongful conduct from otherwise innocent conduct. In United States versus Carter, the Supreme Court looked at a statute in which there was specific language that required, there were 2 paragraphs, that one in which there was specific language requiring that the courts look at this statute as requiring specific intent, whereas a second paragraph had no language and it was just whoever by force written into the language of the statute. The court found that in the first paragraph, we require general intent because there was no specific language. And then the second paragraph required specific intent because Congress expressly laid it out. Further, I would like to point out that petitioner relied on United States versus Steggs as a 7th Circuit case, which illustrated that the court found that Section 111 was a specific intent offense because of the understanding of common law assault. However, United States versus Steggs is no longer good law. It was written in 1977. However, in 1995, if I'm correct, United States versus Woody, the 7th Circuit found that, apologies, I'm just quickly making sure that I have the correct
Take your time.
Date for you. Yes, sorry. So in 1995, the Seventh Circuit found in United States versus Woody that Section 111 is a general intent offense. In that case, the defendant was charged under this statute for forcibly assaulting a federal officer after he accelerated away from the officer and hitting his knee. The court found that even though there was a specific intent standard found in assault, reading the whole statute as a whole.
Counselor, what test should we employ to protect innocent citizens from overzealous police officers and prosecutors? What should the test be?
Your Honor, I believe that the test for ensuring that there are not overzealous prosecutions of innocent individuals is written into the statute. It's very explicitly written that it needs to be forcible conduct that needs to take place in order for something to become a crime under the statute. As it was mentioned earlier, a mother and daughter example where a mother forcibly pushes a federal officer out of the way in order to save her child. However, such examples are anomalies, and we cannot base our jurisprudence based on these anomalies. There are no cases that illustrate that a mother who was trying to save her child was convicted under this statute. So in answering your question, while I cannot say for certain what the test is, it's pretty certain from the statute that we need to make sure that the conduct is done so forcibly. And in order to do something forcibly, it needs to be done with force. And by extension, that does not include accidental or innocent or trivial conduct.
But couldn't there have been an argument, though, that here what we have is a police agent, who basically walks right up and apprehends or touches Exotic, and Kinley is just trying to help his husband.
That's understandable, Your Honor. However, Congress has made it very clear when making this statute that they just require general intent. If the Congress had wanted specific intent requirements within the statute, they would have done so, as they have in several other occasions. It is understandable that in this situation, Kinley had approached the Agent Lafferty and pushed her to save his husband. However, because the statute is a general intent offense, his intentions and the reasons why he did something don't really matter and don't put weight into the analysis that courts are required to do in interpreting the statute.
But what about Agent Lafferty's intent in triggering basically the secession of events? By going over to Exotic to begin with, then you would never have had, how do we know? Kinley may not have even intervened on his husband's behalf had it not been for the agent.
Your Honor,
and her actions.
Respectfully, the actions of Agent Lafferty have no bearing as to whether or not this statute should be seen as a general or specific intent offense. Agent Lafferty could have been doing various other things. However, the action that Kinley took was pushing Agent Lafferty, and therefore—
I understand that, counsel, but I'm trying to get to, again, the test that we should employ. We're aware of what happened here, and the case law is not settled. That we know that more circuits have found it should be a general intent crime, but I'm trying to understand what you say we should impose here at the Supreme Court level.
Your Honor, our position is that this court should find that the statute is a general intent offense by looking at the terms that are used within the statute, including the specific term that has been included of forcibly. I believe that that is the test that courts can establish in finding that the statute is a general intent offense. And eight circuits out of the three who have opposed this statute as a specific intent offense have found that the term forcibly, connected with the dual purpose that Congress had in creating this statute, is enough to establish that we need general intent in effectuating the statute's meaning and Congress's intent.
So, counsel,
Oh, go ahead, Judge White.
I'm sorry.
No, go ahead.
do I understand you to be saying that if the statute had said assault, resist, all of these things, then we would be looking to the common law understanding of the word assault. But because Congress used the word forcibly, that changes the approach, and then we only look to whether the force was intentional?
Your Honor, it's long been established that Congress knows what they are doing when they create the statutes that they create. They know the difference between general intent and specific intent, and they have done so. When they want to make a statute a specific intent offense, they have done so. For example, in 18 U.S.C. section 113, subsection A, it provides criminal penalties for an assault with intent to commit murder. And another statute is section 113, subsection A3, where it's specifically written that assault with a dangerous weapon with the intent to cause bodily harm is a specific.
Counsel, that's different because they can't just use the word assault. It's assault plus. Here, you have a word that has content in the common law. It has some intent with it. So I don't think those are apt examples because they're adding something to the normal specific intent. But I don't think you really answered my question. I said, are you saying that if it had just said assault, then we would take the common law requirement of specific intent, but because they use the word forcible, it turned into general intent? Or am I misunderstanding your argument?
No, Your Honor, you're not misunderstanding my argument. I am saying that because Congress expressly wrote within the statute that the actions need to be done so forcibly, they have created the test, or they have created the requisite analysis that needs to be established by courts to find that the statute is a general intent offense. Had the term forcibly not been written into the statute, it's possible that this analysis would be very much different to what it is today. However, several circuit courts have found that the use of forcibly within the statute is enough to establish that it is a general intent offense.
So let me follow up on that, please. I appreciate your focus on the text of the statute. And you put quite a bit of emphasis on forcibly. But the statute also says whoever forcibly assaults, resists, opposes, impedes, intimidates, or interferes with any federal officer or agency. Isn't it fair to say that terms like interfering, interference, and resisting can only make sense if we examine the purpose behind it, so that there has to be an intent to the interference, an intent to the resisting, such that it would be a specific intent, that there are textual clues that this statute was intended to be a specific intent crime?
Respectfully, Your Honor, I would disagree. I believe that the words such as resist, impose, or impede within the statute, yes, those words in the statute, while on their own may be understood differently, in conjunction with the rest of the terms of the statute, they do not require more than just needing the intent to do the act that is involved, which is why it is argued that section 111 should be read as a general intent offense.
Okay. You know, we're arguing quite a bit over the interpretation of this statute. Are you familiar with the rule of lenity?
I am not, no, Your Honor.
Okay, then I'll let that one go. Opposing counsel suggested that the United States versus Fiola case really doesn't have any impact in how we interpret this statute. Do you agree with that?
No, Your Honor, I would not agree with that. I do understand that Fiola was, and it's written into United States versus Fiola, that it was just a jurisdictional element that they were referring to. However, 8 out of 8 circuit courts have used Fiola in their interpretation of section 111 and have found that based off of the analysis in Fiola, section 111 should be a general intent offense.
Thank you.
So, moving on, Your Honor, the presumption in favor of scienter is met with a holding that section 111 is a general intent offense. This court has reasoned that the presumption of scienter requires a court to read only the mens rea, which is necessary to separate wrongful conduct and otherwise innocent conduct. Petitioner made the argument that by finding this statute as a general intent offense, we would be providing a slippery slope where trivial conducts will then be led into convictions. However, this is inaccurate. It is clear based on the purpose of the statute that innocent conduct would not be effectuated in this statute as a conviction, because we are not only protecting federal officers, but federal functions as well. The main reason for finding that this statute is a general intent offense needs to be understood beyond just innocent trivial matters that might be included into this statute.
About the protection of someone who is mentally impaired, whether they're intoxicated, homeless, and mentally ill, whatever the circumstances might be, you're saying that we should ignore that under these circumstances as long as it's an officer or an agent that's involved with the interaction.
Your Honor, I see that my time is up, but if I could just answer your question and briefly conclude.
Please.
Thank you. So in terms of intoxication, it's long been established that intoxication is no defense when it comes to crimes. However, with respect to a person's mental capacity, we also need to remember that the statute provides for fines and jail time that vary. This allows a judge or a justice to look at the totality of the circumstances when deciding a proper punishment based on the facts of the case. And this would not lead to a gross overpunishment of petitioners or defendants who have a lack of mental capacity. We are requiring that this court completely reject an individual's personal afflictions. However, the statute is a general intent offense, and judges are able to have the requisite knowledge to understand when a conviction is frivolous, and they will not go through with that. Your Honors, we came before you here today with two issues. My co-counsel represented that Beau Exotic was not seized for the purposes of the Fourth Amendment, and I spoke to the second issue as to why Section 111 of Title 18 is a general intent offense. It is respectfully asked that this court affirm the decisions of the lower courts and find in favor of the respondent. If there are no further questions, these are my submissions.
Thank you.
Thank you very much. The case will
Thank
be
you.
submitted. We have rebuttal, don't we?
Yes, we do, Your Honor.
Okay. Who's ready to proceed with rebuttal?
I will be rebutting, Your Honor.
Thank you.
Your Honors, as to the issue of the seizure, respondent relied heavily on the subjectivity of the present case, arguing that Agent Lafferty did not intend to arrest Beau Exotic and that he declined her request 3 times, neglecting the fact that this court has repeatedly rejected any attempt to introduce subjectivity into a Fourth Amendment analysis in an attempt to protect the rights of individuals in this country. Respondent effectively neglected the reasonable person standard as set by this court, and not Beau Exotic, but a reasonable person under these circumstances would not have felt free to decline the officer's request or otherwise terminate the encounter. Your Honors, additionally, with respect to my co-counsel's argument, respondent pointed out that Staggs is no longer good law, and this is incorrect. While other circuits have decided differently on this issue, this case has not been overturned. Accordingly, we respectfully ask this court to reverse the 13th Circuit Court's holding that Beau Exotic was not seized within meaning of the Fourth Amendment and that evidence of Ron Kinley's mental state should be excluded. Thank you, Your Honors.
Thank you.
Thank you.
Okay, so now the case will be submitted. We are going to adjourn and decide the case. And I understand that this period of time becomes particularly excruciating with Zoom arguments for some reason. I thought it was excruciating at all times, but we will do our best to get back with you as soon as possible. Thank you.
Thank you. So judges, if you would please retire to your private Zoom meeting room to deliberate, and please join us when those deliberations are complete. In the meantime, we are going to be awarding our Best Brief and Best Oralist Awards. And we'll give folks a few minutes to situate themselves.
Oh, wait a minute. The chat link is on this meeting, right?
Yeah, Helene, so what I did is I'm going to sign out, but I did copy that 9600341565 number as the meeting that I'm going to put in hopefully when we exit this meeting to start the next.
Yes.
I'm sorry, I didn't copy it down.
Yeah, I didn't either.
Okay, 960.
Wait a minute, here's my chat. Host disabled, screen sharing. Hey,
So in the chat, there is a link that will take you to the Zoom meeting room.
but it's
Well,
been disabled.
It doesn't really.
Okay.
Oh, well, maybe this is it.
Is it the one from Alex Myers?
Yeah,
Yes.
okay,
Okay.
okay. Is there a password?
There won't be a password, Judge White. You just will have to follow that link.
I did.
It's requiring a password.
The password would then be, no, there should not be a password.
I guess there's two
But there is. It asks for email address and password.
Yeah, we hit the link and it's requiring a password.
You might have to sign out of this meeting to go join the other one.
But
Okay.
then, the
But
link,
then we don't have it written
And then
down.
you don't have it down. Can you copy the link into a browser window?
I don't even know if I can get back to the Zoom.
No.
This is very strange. I don't know how to get back. There isn't an option to get, well, let me see if that were, okay, there you are. All right, I will copy this. Leave the meeting.
That worked. Judge Langford Morris, I'm going to send you the link again.
Yeah, I'm not sure how to get back either. I'm not sure what's going on. Okay, now I got you back, but how do we, the link is in the chat, but when you go there, it wants a password.
Okay, then here, this link will work better.
Okay, the new link at the bottom.
Yep. I am the techie. Oh, you're the techie, that's right. Perfect. All right, I will turn this back over to you, Professor St. John.
Sure. Is everyone where they need to be now? Okay. Thank goodness for our tech expert folks. We couldn't do this without you. I couldn't do it without you. So what we're going to do now is Professor Henning and I are going to be awarding the Best Brief and the Best Oralist awards while our judges deliberate. You'll notice that Ms. Natsky has joined us, and she is in possession of the plaques and the awards that if we were in person, we would be giving out this evening. But for now, we get to just hold them up. Please go ahead, Mariah, and show us. Here are the, is that Best Brief? Yep. And we also have Best Oralist, or pardon me, the Champion and Best Oralist awards. And so once those have been named and presented, then we will be sending those out, since unfortunately we're not able to present them in person. And this one is the Champion. So these are the plaques that will be presented to the, awarded to the folks tonight, and then sent to them in lieu of being presented in person. So we will start off with our best. We're going to be naming the top 3 best briefs. And I will start with third best brief. Oh, you're muted, Professor Henning. You need to unmute yourself.
Sorry, I got it. I muted myself just a second ago. I'm going to apologize in advance for butchering names, but third place is Team O with an average score of 86, Massimo Di Giovanni and Caterina Tatamo. So congratulations.
Next best brief, number 2.
Is Team C, Mustafa Daher and Nicole Miller. Congratulations. Oh, and their score was 86.5.
And finally, our best brief award. And so you will eventually receive this plaque. Our best brief award goes to
Team H, Peter Lochbeiler and Tori Padula with an average score of 88.5. Congratulations, all 3 of you. These are amazingly high scores. I'm very proud of all of you.
Congratulations, best brief winners. So now we will move on to best oralist. And so our 6th place best oralist award goes to?
It's a 6th place? Okay, it's a tie. It goes to Anthony.
5th place. I'm sorry, 5th place best oralist.
Oh, that's right, because it's a tie, we went to 5th place. The 5th place, Jocelyn Flemings, congratulations.
Congratulations. I feel like we should have an envelope here. 4th place best oralist goes to?
Allison Spiegel, congratulations.
Congratulations. 3rd place best oralist goes to?
Victoria Shinzing, congratulations.
2nd place runner-up best oralist?
Anthony Piccarelli, congratulations.
And finally, our best oralist award recipient of this beautiful plaque is?
James Murray, congratulations.
Congratulations to these winners and congratulations to all of the students who competed in this tournament. So now it is time to wait on the deliberations. As we mentioned this weekend, we learned that it does feel like an eternity when we're waiting on the deliberations online. But for your viewing pleasure, we have our wonderful tech folks will be posting some information about upcoming events that we're hoping you may join us for. And so we are going to pause slightly right now, and we will resume in a few moments when the judges return with to announce the winner and to provide feedback for our students. So we'll see you back in a few moments.
I don't hear anything. Is there anybody in this room who's able to talk?
Yes, Your Honor.
Okay,
You are the first one to successfully make it back to our main room. So you
right.
do win the tech prize this evening. And we
Damn
are
my
just
face.
waiting. We are just waiting for Judge White and Judge Langford Morris to join us again.
Okay.
Here's Judge Langford Morris back.
Could hear you guys, but you couldn't see me.
Super. Let me just check. I can't tell here, Alex. Is everyone back?
Not yet. We're still waiting on Judge White, keeping an
Okay.
eye on the attendees.
Okay.
Here we go.
Okay, so Your Honors, whenever you are ready to announce your decision.
I still
Okay.
don't see Judge White. Judge White, her video's not on. There it is. Okay.
All right, as you might be able to tell from the amount of time it took us, even though I promised you a quick decision, it took us quite a bit of time to come up with a prevailing party. This is because the arguments were outstanding from all four of the advocates. But just like being a real judge, you have to make the tough calls. And we did make a tough call, albeit by a 2-to-1 decision. So there is a dissent. We won't tell you who the dissent is, but by a 2-to-1 decision, the first team, Ms. DeBaja and Ms. Davis, are the winners of this competition. So with that, I guess we can give a round of applause to those who are watching. And I'm gonna pass off to my colleagues for them to give you brief comments. Who would like to start?
I'll start. Justice Zara did not really stress just how difficult a decision this was. I want to congratulate all of you future lawyers. You were excellent, every single one of you. You stressed strongly the legal arguments. You had a good command of the facts. I loved the eye contact through Zoom. I could feel your passion radiating through Zoom. And it was really an honor to serve as a judge on this year. Of course, you know, we're going to get to Professor Keenan. If he were here, there's no doubt he'd just be shaking his head at how superb you all were. So I don't really have anything negative to say. I really don't. I just want to say that you all have bright futures ahead of you. I can't wait to see you in court soon. And our doors are always open to help in any way that we can. So having said that, I'll turn to Justice White.
I think this was the best moot court argument I've seen, and I've done a lot of these. Normally there's one, two advocates that stand out, and each team has somebody who's a little weaker. It just wasn't like that. I mean, all four of you, I wish I could see all four of you right now, but you were all so good. It was just really a pleasure. And I agree with everything that Judge Langston Morris said. It's really a pleasure.
So let me just add a few things. All four, you were fantastic. I didn't mean to suggest anything other than that. And I agree with Judge White. This is one of the best moot courts I've done in a long, long time. That said, I'd like to give you some tips, because you're young in your career, and as good as you are, you can improve. All four of you would be well served to slow down in your argument. I don't know if you've noticed, but you delivered an argument at a very quick tempo. And when we interrupted you, we are pretty slow and we're thinking about every word that comes out of our mouth and how to pose that question. And when we give you those questions, we'd like the same deliberation from each of you. For example, I asked a couple of questions that I thought, I won't say to who, but I thought that were softballs. I'm throwing up one for you to hit out of the park. You can't assume that every question that comes out of a judge's mouth is adversarial. You know, take what they give you and run with it. Ms. Davis, I told you I didn't like the common law aspect of your argument. And I tried to point you towards the statute because I thought the statute had some textual clues for you. So listen to those questions. And even if you think the common law is the stronger argument, if a judge is telling you maybe there's some textual clues, you've got the knowledge within you. You can pick up on those textual clues. You know, you got to pick us off one at a time. That's how you get a unanimous panel. Ms. Mangiapane, did I say it correctly? Or close enough?
Close enough, yeah.
Thank you. I thought you did a nice job of distinguishing one of the questions that Judge White presented to you, and she, you said, you know, under those circumstances, it would be a much closer call, but that's not what we have here. And then came circling back to what your argument was. That was a good answer. And like I said, everybody was very, very good. Ms. DeBaja, I told you I didn't like totality of circumstance arguments. So you said, well, that's okay. That's what it really is. That's fine. You impressed the people who agreed with you. I didn't agree with you, so I was looking for something else. I was trying to get you to address the question about adding force to the component, and I think you had plenty of there where you could have argued you still win if we add force, because there was force there, but you didn't go down that path. So these are very minor things. You stood in front of three very difficult judges who weren't giving you a hard time. I mean, who were giving you a very hard time, and you held up incredibly well. And each of you are congratulated and make me proud to be a graduate of this institution. So let me just say a little bit more about Pat Keenan. I don't know, let me see if I can find the Keenan family up there. Professor Keenan really changed my life at that school. He was there all the time. He had the absolute open door policy, and he would make time to find an opportunity to sit down with me, to talk about things I'd written, to talk about writings that he sent to me to read, to just go out and have a beer sometimes and talk about family and life. And I miss him dearly. He's a great professor at that school. The qualities he's brought have been picked up by some of the newer professors, and I am so proud that they have this competition named for him. He was a great advocate and argued in front of the United States Supreme Court numerous times, and you can still hear his arguments on the Oyez website. So those of you who don't know Professor Keenan, do a little bit of reading on the Oyez site to understand some of the cases he argued, and then listen to his arguments and listen to how he handled questions. He did not duck a single question that came from the United States Supreme Court. And he would look at each, even though I'm only hearing, I'm not watching, you tell he looked at each justice and called them by name and gave a very strong answer. And when he didn't have a strong answer, he admitted to it. He had great credibility in the court, and he was a great advocate. So he was not only a great professor, but a great advocate. And I would urge the moot court board to suggest that competitors in this competition listen to some of his arguments before the Supreme Court as they prepare to argue in this competition.
Thank you, Justice Zara. That is great advice. I just wanted to point out that there are a number of members of Professor Keenan's family who are present here. And given the unusual format of our Zoom webinar, we weren't able to identify them immediately who was here. And I was just going to read out who were able to be present. And there were some farther extended family that were able to attend tonight that haven't in the past been able to attend, but were able to do so this year because of our online format. And so we have Margaret Keenan, Pat Keenan's wife, his son, Vince Keenan, his daughter, Karen Keenan Simone, his other son, Brian Keenan, and his sister, Maureen Meldrum, and his brother-in-law, Michael Meldrum. So we thank you so much for continuing this important tradition of the Keenan Memorial competition, and we thank you for your continued support of this event. Yes, go ahead, please.
Mute, you're muted.
I didn't know if we got a chance to speak again, but I definitely want to say just a few words. I don't know if we give the awards now or how that's going to work. Do we give the awards first?
Well, it's a little anticlimactic this year in that we have the awards. They are, in Detroit, and we don't have any ability to hand them out. At this point, we usually literally pass out the plaques and the awards. And as I'm sure you recall, we have photos that are done. And
yes.
Unfortunately, this year, we aren't able to do that. At some point, we're hoping that we'll be able to circle back and get our folks together and have those photos done. But yeah, please, by all means, go ahead.
Okay. Well, Alex, I think you should do a screenshot. Get everybody on now and take a screenshot just for posterity.
Absolutely.
So I just want to say that to the Keenan family, I can't see you, but I feel your spirit just emanating through Zoom. And I feel Professor Keenan. I had the privilege and honor of serving as a student under Professor Keenan, and he taught me evidence well. He was such a great professor. He was well loved by the students, the student body. I have to say, many of the students back in the days when I was at UDM, it was U of D, and there were a lot of issues going on at the old U of D, not under the great Dean Crocker that we have now, but long, long time ago. And Professor Keenan was our go-to person. We could go to his office, sit down with him, talk about the issues in the community, at the school, and in our classes. And he was always an open ear and a warm, warm reply, and would help us with whatever it was that we needed help with. So he was a brilliant professor. He was a professor's professor. And I think someone noted that. I think the dean did. The other professors, they just loved him. And I also had the privilege of, when I first got on the bench, he sent me a note that he had what he called an old dog case that he wanted to try. And I was able to get him in my courtroom as a trial lawyer, my former professor. It was really a thrill. And I want to say that it's so, so important for each of you, as Justice Zara indicated, to go back and listen to his arguments, because he was brilliant. And he was always strong and animated and forceful with his arguments. So it's very, very important. And I just wonder, what would he be thinking today if he watched this first virtual Keenan Moot Court final competition? I wonder what he would be saying as we all try to do our best during all these pandemics, but especially COVID-19 pandemic. So I want to salute the students one more time. You did an excellent job. And I know the Keenan family is so proud. And I know Professor Keenan is smiling down. And you didn't seem nervous despite the Zoom format. And it's been an honor and a privilege to serve as a judge for this great competition. Once again, just spectacular.
Thank you, Your Honor.
And yes, thank you, Your Honors. We can't thank you enough for agreeing to participate in this slightly unusual, but first ever, so sort of record-making event. And so we thank you for devoting your precious time to this event, and we thank you for your continued support of our Keenan Moot Court competition and our Moot Court program in general. Thank you very much for your time. That concludes our event for this evening. As I said, it does feel somewhat anticlimactic that we just end on this note. But again, I want to congratulate all of the competitors. You all made us so proud. And thank you so much for our judges and for everyone joining us this evening. Thank you very much. And we're happy that you were able to join us. Yes.
And thank you, Professor. You did a great job.
Yes.
Go ahead.
Thank you.
Thank you. It was a pleasure.
Yes, excellent.
Can we get everyone to do the traditional Zoom wave so I can take a great screenshot?
What's the Zoom wave? This?
That's perfect. Thank you very much, Judge Morris. All right, excellent. Thank you all.
Now, can you get the Keenan family on a pictorial so you can do all of them?
Yeah, sure.
Why don't you do a big showing of them, and we can have this to send out to all of the alumni and students.
Do here.
Sure. That's like putting them on the spot. I told them that they didn't have to turn their cameras on if they didn't want to, but thank you.
They could just have it for themselves. Yeah, they can have it for themselves.
Let's see them again.
Hi, Vince. Hi, Brian.
Thank you, Your Honors. It was such a pleasure. This is Karen.
Where's Marge? Bye.
Perfect. Thank you.
We are always so grateful for this living testament to Dad. He and Judge Zara and Judge Langford Morris, Judge White. The fact that you come back, that you do this regularly with us is great, and we appreciate your commitment to keeping the living memorial going.
Look at all those beautiful children.
Yes, gorgeous.
I don't think they've ever been able to come either. So Zoom has lots of pluses, I guess.
And they all found the arguments extremely persuasive as well.
Although they had different opinions about who won, but that's just a different.
Let me just tell, I don't know if I've told Vince this, but let me just share with all the Keenan family that are here today. I only applied for one federal court clerkship because I was late in the process, and it was a clerkship that Professor Keenan persuaded me to apply for. That was for Larry Zatkoff, and he was a new appointee to the bench. And he said, you get your application in there because he needs law clerks. And he said, I'll write you a letter. And about 4 years ago, Judge Zatkoff passed. And his wife gave me sometime later a file that Larry Zatkoff maintained on me. That was everything from my application, every press clipping that ever had my name in it. And when I opened up the first page, it was the letter of recommendation from Professor Keenan. Boy, did he oversell me, but thank God he did, because it was a life-changing experience that he put me down the road to. And
yeah,
it was a beautiful letter, beautiful letter.
And I've heard you say, Justice Zara, how he really influenced your career.
He did.
Just wonderful. Yeah, me too. Incredible.
I
wouldn't be a lawyer without him.
We had an occasion recently where Theo, who just left, but he's in second grade now, and his teacher was doing a class segment on Thurgood Marshall, and we shared with him the exact recording that Judge Zara, you were mentioning earlier, the Oye recording of Pat Keenan arguing in front of Justice Marshall, and the kids got a lot out of it, but it was a lot of fun to revisit all that. Thank you for remembering that as well.
That's awesome. All right, well, all my best to all of you. It's been a pleasure and a great honor to serve in this capacity. I'm going to sign out now because I actually have to go teach a class shortly.
All right, virtual hugs. Virtual hugs.
Thank you.
Thank you.
Thank you.
Bye-bye.
Thanks, everyone.
Bye-bye.